Over to you, Avinash bhai.
Okay, thank you. First of all, thank you to Arup bhai, Venu bhai, and all the entire group. I was like wondering when I'll get a chance to speak in this group, but at the same time, I was worried because the kind of discussions which I have witnessed, as and when I've got the opportunity to join the group, to join the discussions, the kind of discussions that were happening were mind-boggling. And like I always used to say, and rather whomsoever I've met, I've always said that the kind of discussions that is going on in this platform between 9 to 10 a.m. makes us, like specifically me, it makes me feel that we are not behind. We are not into that kind of discussions and research that is being done by this group. And this is something which is wonderful. Even yesterday, because I landed in Surat yesterday, after traveling of almost 7 days, I was having no clues as to what to speak, how to speak, what contents, what was the perception with which this session is kept, because the art of drafting or the drafting can be in various ways: drafting of the legal representations, drafting of opinions, drafting of any particular document, or drafting as a skill, as a fundamental skill. So I was wondering what exactly is the perception with which I need to speak. So I contacted Arupai also, and at the same time I contacted my younger brother Vishal also, Vishal Podar. So he helped me with the content document wherein he expressed his views that these contents should be taken with respect to the litigation. And at the same time, Arubai also, most of the things were same. But my endeavor today would be to try and address certain myths so far as drafting is concerned. Because generally we come across a lot of myths. For example, you should use legal jargons. There has to be the precedences which should be mentioned when you are drafting a legal document or maybe an appeal. How far that is true? Whether the language of the draft has to be very academic, it has to be full of Latin words, it has to be full of the judgments, or it can be a simple and a lucid language. That would be my endeavor. Also, along with that, how the document should look like, what should be the body in which, or what parts of the body should be there so far as the draft is concerned, and how to look into any draft. That would be the second. And third, obviously, as Arubai has started with the context that when it comes to filing a reply to a show cause notice, or maybe the appeal before the first appellate authority, if we miss on something, how difficult it becomes to face the litigations at the next level, maybe at the tribunal level or the high court level or the Supreme Court level. So certainly that would be my endeavor. So with permission of all, I would like to start with one very simple question. Looking forward for view of everyone, that when it comes to drafting, and specifically a legal drafting, drafting of an appeal, or maybe drafting of a reply to a show cause notice, or a rectification application, or a review application. I'll not go into the aspect of the petitions or the high courts and all, because many of us are, or most of us are chartered accountants, so I'll not go into that. So drafting of an appeal, how do we take it? Whether the drafting has to be in a simple language, or it should incorporate legal jargons to make it more effective. How many of us believe that we need to use legal jargons to make it more effective? I'll start with this query. Yes.
I don't think legal jargon is important.
Correct. Why, sir?
Because it should be in the context of the matter. If there in the context of the matter does not require any legal jargon, so there is no purpose of saying, lex non COVID and cause it. So something which is impossible cannot be done. So giving those places. So only if it is in the context, maybe we can give it, but not generally, just wherever. Then many a times we just say principle of natural justice is violated. So whether what is the context, whether it is actually violated. So that is one thing that I feel.
Sir, we are all bound by the law and we are administered by the law itself. So when we write any reply, it should be as per what is prescribed in the law. So hence it is necessary that it should be as per what is prescribed only.
Okay. Any different perspective? Who agree with the... Yes, Venu sir.
Venuji has also given some.
No, my view is with my interaction with most JCs, they hardly understand the subject in detail. And many of them are from different backgrounds, especially most of them are from either science or arts background.
Correct.
And few of them would have done law. And I say few, it's just 1 to 5% of the people. Now, the context, if I want to shut his mouth saying to show off and say that, okay, this, or if I want him to make really understand what is the issue and how the proper officer or adjudicating officer missed his point, maybe in my view, putting the point in a plain language and of course, taking cue from some legal judgments, the context in which the judgment was fought, rather without quoting the judgment, would be better is always, I think. That's my view.
So therefore, the first rule which eliminates or which is getting out of it is know the audience. So the first rule which as per me, so far as drafting is concerned, is know the audience. Before writing, we should know who the audience is. If you are writing before a state tax officer, who is a state tax officer without having the knowledge or the fundamental background of this particular issue, say for example, service tax. Now, a state officer has never dealt with service tax before GST. So we need to understand what is the level of that particular officer, and accordingly we need to answer. When it comes to, let's say, as mentioned by Venu, by a joint commissioner, we also need to have a background of that particular joint commissioner before writing into that. When it comes to court, for example, let me share an example. Like presently in Gujarat High Court, the judge who is leading the tax bench, he is a chartered accountant turned lawyer and turned judge. So therefore, he understands the tax well. So we need to understand that he is already well versed with the tax provisions or the basics about the taxation, and therefore we are not supposed to explain the basics of the taxation to that particular judge, and therefore we can start our representation or the drafting from a second level. Otherwise, first and foremost rule, as per my limited understanding, is knowing the audience is something which is very, very important. Unless we know to whom we are representing, to whom we are making a submission, for the purpose of what we are making this letter or the document, will not be able to put the words which we want to add. So therefore, yes, 110%. My understanding also says that the reply or the submissions or the drafting has to be as simple as possible. It need not have legal jargons. And as rightly mentioned by all the participants, including Venubhai, there may be a requirement at times that we need to quote certain judgments. But please understand, unless the officer who is well versed with the facts of the case, unless the officer who is well versed with the law which is going to be implemented on those facts, unless the officer is, I would say, accepting the arguments that we are placing forth, he will never be appreciating the judgments which we are relying upon, because he will try to distinguish those judgments or he will try to run away from following those judgments, even if those judgments are, I'd say, binding on him or having some precedence. So therefore, my limited understanding would be, and my suggestion would be, that you have to be, like, we all have to be very clear about the audience before whom we are going to present the document that we are drafting. So the first rule as per me would be the awareness or the knowledge about the audience. Second rule, which my understanding says would be the loading of document or the document has to be loaded in such a way that the context should come at the inception. So therefore, let me now put it in this way. If I have to draft, let's say, a reply or an appeal, there is a standard format which is given. For example, if I'm not wrong, it is APL 01 for filing of an appeal. That is the form which needs to be filled. So now while filing that fill, there are certain contents which are certainly going to be there. It is mandatorily required. Am I audible? Because there is some disturbance of Ganpati Mahotsav and all. Am I
Yes, sir,
audible?
audible, sir.
No,
Audible,
no,
sir.
your voice is
Yes,
clear.
you're able to.
Okay, okay. So the context is very important, but the document format at the same time is is another very important aspect. So what I do personally and what I suggest personally would be that whenever a standard format is there, we are bound to follow that format, APL 01 or DRC 07 or DRC, whatsoever formats are there. We need to follow those formats. We cannot deviate from that. But certainly, in addition to those formats, we can have a well-drafted statement of facts and well-drafted grounds on appeal. When I say so, or a reply to a show cause notice, which is not having any boundaries that what you need to write, how you need to write. I would suggest the original should start with, or the origination should be from the introduction. We need to introduce ourselves. The person who is replying back to a show cause notice, or the person who is filing an appeal, or any or who is the author of the document. Let me put it in this way. Now, when the introduction is given, thereafter we need to set the context. When I say set the context, means that we need to point out the issue which is involved in that particular case or that particular matter. Because unless we put forth the issue which is involved, he may not be interested in reading a long document of 10 pages or 15 pages. So therefore, the context in simpler words, for example, when we file an appeal before the tribunal, or when we file an appeal before the High Court, there are the question of law which needs to be framed when it comes to the High Court. And at the same time, when it comes to the tribunal, we are framing the factual questions which have to be decided by the tribunal. So therefore, the question or the context has to be formulated in such a way that reading those 2 lines or 3 lines, 100 words, the officer or the adjudicating authority or the appellate authority gets the context in regards to which the entire document is being drafted. Third would be, the first is introduction, second is context as per me. Third, as per me, which is again very important, is the facts of the case. Then we need to come to the facts of the case, which is again extremely important, because generally what I have seen in most of the submissions, most of the drafting is they have mixed facts, mixed law. At the same time, the context is never drawn. So facts have to be mentioned in such a clear manner that no confusion arises, because at most of the stages, I would say, the facts are considered. Even at High Court and Supreme Court, see, High Court question of law is important when we file appeal. There has to be a substantial question of law, but at the same time, it culminates, it originates from the facts only, because it is the fact only which help the courts to distinguish from their past precedences. Henceforth, the facts are something which is very, very important. And therefore, after framing the entire issue in not more than 100 words, 75 words, setting the context, we should go into the facts. And the facts have to be narrated very, very succinctly. It has to be very clear and as simple as possible. Now, when it comes to as simple as possible, and when it comes to a statement or stating the facts, Another very important issue would be, or another very important rule, I would say, would be, we should avoid the chronicling. We should avoid a lot of dates, history, because generally I have seen, to make it impressive, it is a tendency of the draftsman or the author that they want to make their document impressive or create an impression on the reader. I would say the impression gets created only when you are simple and only when you are able to communicate. And therefore, the the purpose should be communication, that we are able to communicate with what we wanted to communicate. So therefore, we should avoid a lot of history, lots of dates to be mentioned, because those are not to be remembered, or nobody remembers that. Whatever is relevant fact, only those facts should be pointed out, those, and that too very, very clearly and very, very strongly. So the after the facts, the next would be the grounds. When it comes to grounds, there comes the legal understanding of the law, and there comes the technical understanding of the law, and there comes the issue which is being given to me, which needs to be addressed, as given in the context of Arup Bhai, Venu Bhai, that when we file a reply to a show cause notice, what things needs to be taken care of, so that when it comes to the appellate or the second appellate or third appellate level, there is no issue, there is no problem which arises because of something being left out at the time of filing of reply to the show cause notice. So I'll just try to reframe the discussion that we had till now, and then if any queries are there, then thereafter I'll move ahead. First, my understanding says we should introduce ourselves in the best possible manner, what we are doing, what is our business. Then we need to point out the exact issue which is there, so that the reader or the officer need not read in detail. After reading 10 pages, he comes to know, this was the issue. No, that is not required, sir. Please set the context at the initial level only, so that he can understand the issue. And if he's already made up his mind, like after reading the issue, if he is clear that the issue is bogus, it should not be stretched. He will automatically go into your grounds and he will decide the issue. So therefore, context becomes important, and thereafter the facts of the case, and then the grounds. And when it comes to grounds, because facts and grounds are something which is very important, which comes out from the show cause notice reply, which comes out from the first appellate order, and therefore that needs to be drafted very, very particularly and succinctly. But at the same time, we need to avoid a lot of chronicling that need not be there, because most dates are, as per me, are unimportant, are not important. So therefore, emphasizing on the dates, emphasizing on those facts which are the history, may not create any impact. Unnecessarily, it will increase the number of pages. So therefore, the another myth in drafting which I've experienced while discussing with most of the colleagues is, draft बहुत बड़ा होना चाहिए. Make a draft of, for example, there is a show cause notice of 50 crores. We are charging a X amount, which is, let's say, a reasonable amount. Then the chartered accountant will have to file a reply of 500 pages, 200 pages, 100 pages. This is what is a myth. Sir, that is not required. We are not here to show to our client that we are charging you 10 lakh rupees and therefore we have filed a reply of 100 pages or 200 pages. No, sir, that is not required. Required is, even if you are able to do, because that is your skill, that is the experience, that is the labor that we have given for 20 years, 30 years in our life, and gained an experience of how to handle such cases. And therefore, even a reply of 2 page, which set the context and which brings out the entire facts and the law or the grounds, will be more than sufficient. So therefore, another myth would be, as per me, when it comes to drafting, is बहुत लंबी drafting करो. Let me share one example of mine, live example, when I was appearing in CA examinations. When I appeared in CA intermediate examination in the exam, in the I think paper of income tax. Income tax used to be a tough subject when I was the student in 96, 97. direct access finals also and intermediate also. So generally I've seen supplementary copies. A lot of people were taking supplementary copies, and I've written only 18 pages, only 1/8, only 18 pages. Even the first answer sheet was also not complete, because I think 24 pages were there. I wrote only 18 pages. I was so afraid. There were no sections mentioned. I have not mentioned any section. I have not mentioned any case law. It was simply the question what was asked, and I only replied to that. I scored 94 marks in that particular paper, which was highest in the CA curriculum of that particular year. So the point which I'm trying to raise here is, we are not supposed to be elaborative. We are supposed to be objective. Objectivity has to be there in our reply. Objectivity has to be there in our document which we are drafting. Therefore, while making a subjective submission, or while making a very elaborative and detailed submission, we generally put certain words in the mouth of the respondent or the other side, because he will pick from your submission, detailed submissions, and then he will try to screw you. Don't do that. The point which is being raised, or the point which is there to be covered, please stick to that point and reply to that point. That's it. So therefore, a detailed reply or a lot of case laws to be relied upon, a lot of legal jargons, legal maxims to be used, as per me, is nothing but a myth. So don't go into that. Be as simple as possible and be as straight as possible to avoid any kind of confusions or to avoid any kind of misconceptions or misleading. I'll just give an example of how to write. Say, for example, there are 4 options or 4 different connotations. For example, wherein we are using comma, red, comma, blue, comma, green, and yellow. Now, please try to understand the point. Red, comma, blue, comma, green, and yellow. This is one way of writing. Another way of writing is red, comma, blue, comma, green, comma, and so and so. These two have different interpretations. Because when I say red, comma, blue, comma, red, green, and black, so that can be read as green and black, because both have to be read in conjunction. But when I say red, comma, blue, comma, green, comma, and black, it means red is separate, blue is separate, green is separate, and then black. So the point is, use of comma at times becomes so important that a lot of interpretational issue comes. And you all have witnessed, rather we all have witnessed. And I've attended many times the SMS, and always I've seen a lot of discussions going on these various issues. But these are the drafting errors, and we need to avoid those errors. And therefore, the simple we would be, the better it is going to be when it comes to litigation or when it comes to future issues creeping up from our own drafts. See, another experience of mine is I have seen most of the issues which is creeping up is because of the drafting errors. They point out the mistakes from our own drafts and then they build their case, unfortunately, because we believe that we have to reply back in 100 pages. And those 100 pages contains a lot of such discussions which are absolutely not required. And when we contain, or when we comprise of a discussion which is not required, that discussion may lead to a wrong path. Another example can be replying to a show cause notice which alleges that your supplier was found to be non-existent. Now, many a times I've seen a reply wherein they will start from section 16.2. They will start explaining entire 16.2. They will say, we have received the invoice, we have received the goods, so on and so forth. That was never the allegation. Where is the question of 16.2C? 16.2AA, it is not at all the allegation in the show cause notice. Why are you replying that? That means you are putting the words in his mouth, and now using those words or using that reply, he will try to elevate his case or build his case. So therefore, my humble submission or my humble understanding is, be as simple as possible, and at the same time be as short as possible, straight as possible. So that is the first aspect which I wanted to deal. Then I'll now come into how to deal with the replies and all. If any discussion has to be done or any queries are there, most welcome.
Sir,
So if there are any questions, you can address to.
sir, you said chronology is not important, but many times.
No, sir, no, ma'am, no, ma'am. I have not said chronology is not important.
Okay.
I have said chronicling is not important. Chronicling means putting a lot of dates in the history.
Okay. Okay.
This happened on that day, this happened on that day, this happened on that day, and then we did this. That is not required. A lot
Okay.
of dates, because that is irrelevant.
Okay.
It is not chronology. Chronology is most important.
Yeah, that's what. Yes. Yeah.
Chronicling is not important.
Yeah, got it.
Sir, sometimes we found that the show cause notices or the orders are containing various judgments and various legal maxims as well. In such
Correct.
situation, what is expected that whether we should reply in same manner, same format, or detailing with the various maxims and judgments, or we should go as you are suggested that we need to be very simple and straight.
So therefore, now the officer who is issuing the show cause notice, with due respect to him, he is trying to step into our shoes and try to expose his experience and the knowledge. Unfortunately, the show cause notices, which is placing reliance on a lot of judgments, as per me, is not a show cause notice, it is an order. Mr. Anand, if you can understand the query.
Yes. Yeah.
Understand, because that is an order. And therefore, the moment he writes a story saying that these are the judgment which is binding, and these are the judgment which I am relying upon, and on the basis of these judgments, I am issuing a show cause notice, that means you have already pre-decided. It is not a show cause notice, it is an order which is a predetermined mindset. And the moment this is there, we need to raise a technical objection. Look, sir, this is not not giving an opportunity on the facts of my case. You have already made up your mind, relying on a judgment which is identical on the same facts, or maybe slightly on a different facts. So therefore, this is not giving an opportunity. It is not a reasonable opportunity. The first objection that needs to be raised is this. I hope I'm clear.
Yes.
Now, when
Yes,
it
thank
comes
you,
to
sir.
replying back, first is, see, what my perspective is, can I use Hindi also? If
Yes, sir.
everyone
Yes,
is
sir.
comfortable.
No,
Just I want to convey one line. Generally ऐसा होता है कि जो हम बोलते हैं वो हम follow नहीं करते. Because when it comes to preaching or teaching, many of us do not follow, and what we set a grain, what I can say, एक level बना देते हैं, but we tend to avoid following that. This happens to me also. When it comes to sharing the experience, sharing how it has to be done, we do that. But the team does it or team doesn't does it, we are not having that control. But the important aspect is, whenever such queries are there, I always say there has to be reply on 2 counts. 1, technical count. 2, legal count. So therefore, the question of Mr. Anand was, if they are raising a lot of legal maxims or entering a lot of legal maxims and the case laws, relying on those case laws, and they are drafting a show cause notice to us, I would say the first technical objection that we need to take is, this seems to be an order. This seems not to be a show cause notice, but an order which has been passed in the shape of a show cause notice, because you are going to follow this. Therefore, it is not a reasonable opportunity being given to me, and therefore it is devoid of the or violative of the principles of natural justice. That has to be in the reply. Thereafter, we can start replying on the merits also. I'm not saying that don't reply on merits. So therefore, technical objections or technical replies are as important. Pointing out technical limitations like technical flaws, for example, jurisdiction, limitation, is very, very important. Rather, I would say equally important than replying on merits. So, Mr. Anand, the reply would be, first, raise the technical objection that this seems to be an order, and then you can reply on merits. If you want to counter all those judgments, you can counter or try to distinguish that, or otherwise I'll again insist stick to your facts, stick to your reply. That is as simple as possible. And as when we started discussion, I think there was Soumya madam, someone who mentioned that we are bound by the legal phraseology or the law. Therefore, the more nearer we are to the law, the better we are going to get the results. The more we are towards the legal precedences or the case laws, the difficult it is going to be so far as acceptance of the people are concerned, that they may not accept or the officers may not accept. Unka bhi thoda ego hurt ho jata hai. So better is to stick to the facts of the case, to stick to the law which is applicable, and just make a simple reply. Even if he has quoted a lot of judgments, you are not supposed to distinguish those judgments in your reply. You can simply say that these judgments which you have referred is not applicable to me. During the course of personal hearing, I'll come and explain why. Don't try to fight on all those issues. This is what I would say. Yes.
Thank you, sir. Thank you.
Sir, one other point I had to make. Sir, when I was saying that, when you were saying that we need to bear in mind the audience while we draft the reply, whether it's a joint commissioner or assistant commissioner. But we know that the resolution for the issue is not going to happen at that level. It may be like we will have to take it up to the last level. And therefore, that we raise these objections at the initial itself, that should be recorded somewhere, right? We cannot take it at a later point. So even though,
Correct.
joint commissioner is not able to understand, I feel all these points have to come at the initial stage itself.
Correct. Correct. Ma'am, what I wanted to say was, knowing the audience is important when it comes to drafting the reply or drafting the document. The context was that the language has to be used in such a way that he understands that language. Meaning thereby, and I gave an example of a judge sitting in Gujarat High Court nowadays, who is a chartered accountant. So therefore, no need to explain the basics of taxation. So knowing the audience means that when it comes to an inspector or a superintendent or a JC who is not from this field, who is a new or do not have that much experience, our language has to be molded. The context has to be set in such a way that he understands the entire gamut of the submissions which we are making. I never said that you compromise on the submissions to be made. Everything which is relevant has to be put forth. We can never escape that because the person will not understand. It is not our duty. It is not our endeavor to make him understand. It is our endeavor to make or to bring everything on a document which we want to contend. So therefore, ma'am, I'm extremely sorry if I've conveyed wrongly. The purpose of knowing the audience was the context and the language which is to be used, and from where we need to start. If he is a chartered accountant, he understands taxation well. We are not supposed to explain the basics of taxation to him. But if he is an art graduate, we are supposed to explain the basics also. That was the context. Not that we need to miss on some of the important aspects. No, never. I'll come to that also. I'll come to that also in next 2-3 minutes. But
Thank you, sir.
just so far as framework is concerned, it was only to be framework.
Sir, but in this faceless world of litigation, how do we, understand that the officer is competent enough to understand or not understand his knowledge level or something like that? Because nowadays we handle notices pertaining to other states also. So it is impossible for any consultant to know the background of the authority or, officials in charge of that particular jurisdiction.
I appreciate, ma'am, and absolutely you are bang on the point, and therefore the answer would be very precise as possible and as simple as possible. The language should be as simple. Assume that he does not know anything, and the way you will draft, you keep on drafting in the same manner, and therefore the rule has to be followed that please keep it short, please keep it simple and lucid. Don't use legal jargons, nothing. So therefore, whether it is a statement of facts, whether it is introduction, whether it is the creation of the context, or whether it is the grounds of the appeal, everything needs to be complied in such a way that any layman can understand. Just stick to this formula. Don't go into detail. See, the point of knowing the audience was that we can shift to a second level, or we can elevate the submissions to a level if he is already understanding the basics. It happens in the courts. It happens at the tribunal level. But when it comes to reply to a show cause notice, because ma'am, the query which you have raised, as per me, pertains to a faceless of regime when it comes to the adjudication or when it comes to the first appellate level. But when it comes to second appellate level, we need to understand the tribunal members, and accordingly we need to present the cases. Now, obviously, in the second question which can come is, okay, sir, we are filing appeal today. It is going to be heard after 3 years. We never know, because we have set the context looking to Mr. Avinash. Now it will be heard by Mr. Vishal. He's a different person, maybe having a different perspective, but therefore the underlying rule has to be followed, and which is keep your document, keep your draft as precise as possible, as short as possible, and as simple in language as possible. Don't use legal jargons, which I personally avoid. Don't use the legal, the Latin maxims. Don't use case laws. This is my personal experience, that we need not use that when it comes to the first document being filed. When it comes to the extended arguments, then certainly we are supposed to rely upon the judgments also, and the legal maxims also, and the international laws also. A lot of things have to be relied upon. Anyways, some of the additional points which I would like to share here would be: one, there has to be a decision taken at our end that footnotes must be avoided. We must avoid using footnotes when we file a reply to a show cause notice, when we file appeal. Citations can be mentioned in the footnote, that's not an issue. But otherwise, the footnote generally kills the momentum of reading the document, because when we read a particular document and there is a footnote marked 1, and then we need to go to the footnote and read what it says, generally we miss the momentum, and therefore footnotes must not be there when we file a reply or when we file an appeal. In most of the documents I have seen, or rather, if not most, then many of the documents I've seen, that there are a lot of footnotes wherein they say the source is this, and then they reproduce the entire context of that source. That is not required as per me. That has to be on the main body of the reply, or on the main body. So therefore, the citation, I personally believe, yes, it can be on the footnotes, and we'll find in most of the commentaries, you'll find the same. Another very important aspect when it comes to drafting is, because these are some of the fundamental rules which I personally believe must be followed, is short sentences. The sentences which we are using must be as short as possible. If we start using long sentences, 4 line ka ek sentence bana diya, then it happens with us also. When we read a particular law having 6 lines as one sentence, generally we miss out, and we need to read it time and again and again to derive the context and the meaning with which, or the purpose with which, the particular paragraph is written. So therefore, simple line and short line, not very extended formats. And last but not the least, as per my understanding, is the voice of the drafting has to be active. It need not be passive. Use active language while making a reply to a show cause notice. Although persuasive language or persuasive has to be there, but not the passive. Avoid using passive languages or passive terms. Now, as queried or as asked by Arup Bhai to cover, or he has indicated that this is the perception with which the session has to be taken forward, is that what things needs to be kept in mind over and above these fundamentals that is there for each drafting, whether we draft a particular letter, document, opinion, a book, anything. What other things are important when it comes to a higher forum litigation? So I would say two bifurcations, which I've already stated. One, technical objections, two, legal submissions on merits. Technical objections, for example, limitation, you have the show cause notice or this barred by limitation. Two, jurisdiction, although you have no jurisdiction. Now the question arises where to place this, because the order which I have stated or the order which I have shared is first introduction, second the context, third facts of the case, and then the grounds or maybe the submissions. So where is the place where to place this? My understanding says that when we are raising a technical objection with respect to jurisdiction, with respect to limitation, with respect to the monetary limits, with respect to the cross empowerment. So we need to keep in mind that whenever such technical issues or technical objections are being raised by us, this should come after we set the context and before we give the facts. This is my way of understanding this, because if we are raising an objection because of which the entire procedure on the entire the proceeding can be dropped, that should come at the top. Generally, I have seen a submission where I have found that these technical objections are at the last, because क्या होता है, ऑफिसर नाराज नहीं हो जाए, ऑफिसर should not feel bad, and therefore हम छोटा सा कहीं लिखेंगे लास्ट में, let me first reply to the entire show cause notice. I will take it other way around. If we are having the technical objection, that should be raised at the inception, and therefore the space which I would locate for these technical objections to be raised would be after setting the context or the issue which is there. So therefore introduction, after introduction, the context in not more than 100 words, the issue which is involved or the questions which are being raised or the dispute which is there, then technical flaws in the show cause notice or the technical objections whatsoever, whatever word you want to write, we can write that. Thereafter, without prejudice to the above, we are now replying on the merits, and therefore the statement of the state of the facts or the facts of the case. And after narrating the fact, then the submissions on the legalities or the legal grounds. For example, limitation is there. आपका ये suppression is there. He is alleging or he is invoking the extended period of the limitation, whereas you are raising an objection so far as suppression is concerned that there is no suppression. That is a technical objection also. It is a legal objection. Certainly, it is on merits also. You need to point out the merits that this was there in the balance sheet. You came for an audit. During the course of audit, you found that, which is recorded in my balance sheet, there was an interpretational issue. So therefore, it cannot be a cause saying that there is a suppression. But at the same time, this is also a technical objection that you cannot invoke the extended period of limitation and therefore raise this technical objection that this period needs to go. Follow 75(2). So technical objection should come at the top. That is as per my understanding, that this is what I would do if required to do. Next question was that if I am filing, let's say, a appeal, and if I missed on certain submissions at the show cause level, what would happen? Can we add those additional grounds? Can we add those additional evidences? So therefore, to understand that, I would say we need to understand the provision. If it is a case of first appellate authority, qua GST, I'm not going to other laws. Qua GST, it is section 107, subsection 11, if I'm not wrong, which is placing an embargo, a restriction. And that embargo is that the appellate authority cannot remand back to the adjudicating authority. Therefore, can we expect the appellate authority to step into the shoes of adjudicating authority and decide or adjudicate? My answer would be no. We cannot expect an appellate authority to step into the shoes of the adjudicating authority and go into a trial conduct nahi kar sakta. He cannot go into the evidences. He can ask for the documents, invoices, e-way bills, and all those stuff. No, he cannot do that. He's not expected to do that. If he want to do, he can do it, but he's not expected to do that, and he do not have a power or remand also. And something which is coming on record for the very first time before him is going to be a challenge. So therefore, again, I will reiterate, knowing the audience and submitting a reply are two different aspects. Knowing the audience will help you in deciding what kind of language you have to use and from which level you have to start, from the very basics or from a elevated level. But when it comes to filing a reply, it has to be a comprehensive reply, considering the fact that this litigation, it may be, or it may become a part of litigation, this issue may travel to High Court or Supreme Court. Presuming that we should frame the reply on merits, and reply, as I've already stated, I would always place on two counts: one, reply on merits; two, reply on technical flaws. If there is any technical flaw, DIN is not there, it needs to be mentioned, and it needs to be said that on this basis, on this sole basis, the entire proceeding needs to be dropped. Now, when it comes to second appeal, second appellate authority, I think second appellate authority has a power of remand. Therefore, now, when it comes to power of remand, whether it is a second appellate authority or the High Court or the Supreme Court, it doesn't mean that anything and everything which is not submitted at the initial stages will be accepted. And the remand will be allowed. Meaning thereby, it is dependent on the discretion of that particular appellate authority or the higher authority to accept the additional evidences, to accept the additional grounds, or deny it. He may also deny that. If he accepts the additional evidence, meaning thereby he will remand it back, saying that these are the additional evidences which has placed before us, which have not been considered by the adjudicating authority, and therefore we are remanding it back to the adjudicating authority to re-adjudicate on the basis of these additional evidences. When it comes to additional grounds, generally the grounds are considered by that particular appellate authority then and there itself. For evidence, he will send it back to the adjudication authority. But my experience is, for legal grounds, he will adjudicate himself. So the answer would be, if we miss out on any aspect, whether it is a document to be submitted or a particular point or a particular legal argument which is to be taken, forget about the case laws to be relied upon. Forget about any legal maxim which is applicable. These can be placed before any authority at any point in time, because it will not lead to remanding back the matter. It is merely relying on a particular judgment or a precedence. So therefore, that can be at any point in time. Uske liye koi tension nahi hai. Issue is something with some point which you wanted to cover, but you have missed to cover. For example, burden of proof. Section 155, if I'm not wrong, Section 155 of the GST law says that if you are claiming ITC, then the burden of proof lies on you to prove. Similarly, if the person or if the officer is alleging an offense, the burden of proof lies on him. He will have to discharge his burden of proof very succinctly, that this is why he believes that. And then the onus shifts on you. Burden cannot be shifted, so burden he is discharging by giving a detailed show cause notice that, look, your purchase from Mr. Avinash, he is found to be non-existent. Therefore, why your input tax credit need not be reversed, or why you should not be asked to reverse the input tax credit. Now the onus shifts to you, and onus would be to place on record all the documents and make a submission that, look, what was within your control, you have done that. These are the documents which proves these are your external documents, these are your internal documents, meaning thereby stock register, inward register, movement to for the manufacturing process, then the manufacturing happened and everything. And then your external documents, invoices of the supplier, the e-way bill, the FASTag reports. Because nowadays, even the courts are very smart. Courts do not accept the pleadings where we say that we have e-way bill, we have the purchase invoice, we have made the payment through bank. Court will say this is applicable in every case. You prove that you have received the goods. And therefore, these submissions have to be there at the initial stage. We will not be in a position to deviate from these submissions or add these submissions at a later stage. So therefore, my answer, because of the paucity of time, my answer now would be, sir, when it comes to the reply on facts, when it comes to putting forward the evidences, when it comes to relied upon documents to be placed before the court or the adjudicating authority, it should be there in the reply in the first level itself. But when it comes to grounds, you may miss on certain grounds at the first level, then you can have additional grounds placed before the before the appellate authority or the courts. And generally they permit if it is a logical ground and you give a reason why you have not taken that ground at the initial stage. They will not object. But when it comes to evidence, generally they try to deviate, and they generally try to shy away from taking the cognizance of those evidences, even if they allow the additional evidences to be placed on record. They may not decide on the basis of that, because those authorities are not expected to be the adjudicating authorities. So they will remand it back. And henceforth, the initial replies are something which is very important. Now, one more question I would like to touch upon, which again was raised by Arup Bhai, and he has requested me to cover that. And that is, at times what happens is there are orders which we don't want to go to the appellate stage. We want to challenge it before the writ court, before the constitutional benches of the high courts. So whether there comes any problem, or there may arise any problem when it comes to filing a writ petition, I would say generally a writ petition against a show cause notice or against an order is not maintainable. The court will not admit it, because the court always relegates us to the alternate remedy. The court will say there is an alternate remedy in the statute, go and exhaust that alternate remedy. Yes, there are certain precedences, like Whirlpool Corporation started with that, and recently Commercial Steel, wherein the Honorable Supreme Court has let down certain parameters within which if you fall, then you can go to the writ court directly. But what is the result of that writ court? You can go to the writ court will not decide on merits. Writ court will say, okay, fine, there was a violation of principles of natural justice, your replies were not considered, you were not given the personal hearing, no problem, we'll relegate you back, we'll remand you back to the adjudicating authority. Now he will put forth the detailed show cause notice. Now he will try to sort out all the issues which were there in the erstwhile show cause notice or the erstwhile proceedings. We quash the entire proceedings and send you back. What is the result that you get? No, absolutely no result at all. Unless it is a case wherein they have adjudicated you without hearing of 200 crores, 20 crores of the pre-deposit is there. So in normal situations, we are not supposed to go to the writ court when it comes to show cause or the first appellate level. It is not maintainable. But yes, there are certain extraordinary situations wherein we can go. But at those stages, certain aspects which you could have taken care at while replying to a show cause notice plays something which is plays an important role. For example, nowadays a query which is being raised is, personal hearing was not given. Most of the issues which is before the court is personal hearing was not given, or our submissions were not considered by the authority. So that is nothing but a limb of the principles of natural justice. And there is a specific provision of 75(4) in the Act also. So most of the courts are remanding it back. So there we need to place an eye upon that while replying to the show cause notice, DRC 6, I think there is an option of yes or no. Most of the times it is clicked on no. Although now the courts have taken a view, even if it is no, and if the adverse decision is to be taken, you will have to decide on like you cannot give decide without giving an opportunity of being heard. So anyways, not going into all that, but yes, your replies certainly matter when it comes to the writ code, when it comes to filing of a writ petition, because if we miss on certain aspects, then that may come in our way when it comes to filing of a writ petition. So that was another query of Arup Bhai. Now I'll try to sum up this because almost time is over, and I'd like to invite some of the queries, if any. One, when it comes to drafting, the most important myth is the language. My answer would be simple. Second is the number of pages, the extended, elevated, or elaborated draft. My answer would be short would be better. The lesser you speak, the better it is going to be interpreted. Although it is difficult. आपको बोले 10 पेज में लिखना है कुछ, you will be elaborating and you will be writing it very easily. But when it comes to you will have to write, you are said कि आपको एक पेज में लिखना है, context पूरा, that will become difficult. But there the selection of the words would be very good, and the chances of misinterpretation would be very less. So therefore, simple and short. Third, introducing yourself is something which is very important. Setting the context of the issue at the inception is very important. What I do in couple of my replies when I've suggested to my office that after setting the context, you also set a context of the issues which is being raised. You write the issues at the inception level and one-liners how you address those issues. And then you set the paragraph that in these paragraphs you will find the detailed answer. So if he is convinced by reading that context that this was an issue, that the suppliers were non-existent, your reply one-liner is, when we procured the goods, the supplier was existent, his registration was valid, and therefore the purchases are valid, or the credit is rightly taken. So now you have set a context, the issue. There are 4 issues, point out all those 4 issues, and your one-liner replies or 2-liner replies, and the detailed reply at the end. So setting that context is something which is very important. Third, then thereafter, if there are any technical objections that you are raising, you can raise the technical objections. Thereafter, the statements of the facts, and then the grounds or the contentions which you want to raise for replying to all those issues. So the result that the conclusion that we can draw is that we need to reply issue based. We are not supposed to reply on the law. We are supposed to reply on the issue which is being raised in the show cause notice. And if they are raising an issue of a non-existent taxpayer or non-existent supplier, please reply only on the non-existency of that supplier. Do not reply on 16(2)(c). Do not reply on 16(2)(AA). Do not reply on all those aspects which is not expected by you to reply. You reply only on the allegations which are there, and therefore the reply need not be a law-based reply. The reply has to be issue-based. So this is what I wanted to share. It is 10. I was asked that I have a time of 9 to 10. I tried to restrict and share whatever little bit of experience I had. I'm extremely sorry I could not have any presentation because I was continuously traveling. So please excuse me for that. If any queries are there, most welcome. If any discussion has to be taken place.
Sir, nowadays we see that both the department as well as the taxpayers have started using AI to draft. What's your view on that?
I think Venuba is not there. Now, in his absence, I can certainly say I am against AI. No, see, when it comes to drafting a particular settled principle, AI can be helpful. When it comes to drafting a particular issue-based reply, I personally believe drafting may not help. See, for example, not providing a personal opportunity of being heard. This query being raised to an AI tool, they will reply on lots of judgments. They will throw upon you lots of judgment. But the facts you are well versed with. So my personal view is AI may not be helpful when it comes to litigation. It is certainly going to be helpful when it comes to a system dependent replies, or maybe like audit reports. Audit reports has a particular format in which it needs to be drafted. So there the AIs may help, but when it comes to issue-based litigation, I don't think that is going to help. Yes, in research it can help. A lot of case laws, a lot of other materials it can certainly place before you. But when it comes to filing a reply, I think you should go into your personal understanding only. Venuba is there. He has also replied. Yes, certainly I agree. I have also answered this, that it can very well help us in understanding the context of the case.
So Avinash bhai, it's 10.
Yes, sir. I'm done.
Right. Uni, over to you for the vote of thanks. But before giving it to you, definitely thanks to Avinash bhai for giving his experience. Like what you have said is nothing from the books, but you shared what you practice, and that's a real eye opener for many of us. Always have a doubt that okay, should it be a lengthy one? Should it be with case laws, without case laws? How to approach? But your practical insights definitely guided us. Yeah, thank you.
Thank you.
Uni,
Thank
to
you,
you.
Avinash sir. We often hear that there is a huge difference between knowledge and wisdom. So knowledge we were gathering every day by reading the text. What you gave us in 1 hour today was your wisdom of how to apply that knowledge in filing those replies, and knowing the audience as well as how to use your pleadings before the authorities to effectively communicate what the issue is and getting a resolution there. So I'm sure that the people here would have been surely appreciating the fact that you should be very tactful in filing your replies. I'm sure that this is going to be one of the key considerations we'll be taking going forward, since the litigation doors are open. And we are very blessed to have you in a Saturday morning, even though you have a very busy schedule. I'm sure that you will be participating in more and more SMS in the future, and then you're also participating in the group discussions in the chat. So we are always fortunate to have your views on very critical issues. And thank you all for again coming on this Saturday morning. We will see you again next Saturday for another wonderful discussion on SMS. Thank you all.
Thank you very much. Thank you.
Thank you all. Good day.
Good day.
Good day.